Um, Joey, you have probably represented hundreds of EB-5 investors since 2022. And, as of now, we all know that we've been sounding, alarms on the retrogression. But EB-5 is still, as of now, the most effective ways to help a lot of our investors to gain almost immediate legal status in the US. And I assume most of the filings that you guys are working on nowadays are concurrent filings. Could you please just share with us what exactly is concurrent filing, how does it work, and what is the benefit that to our investors at the moment?
Sure. A concurrent EB-5 filing means that you file your EB-5 petition, the I-526, showing your lawfully obtained capital has been invested into a new commercial enterprise. And at the same time, you're able to file your green card adjustment application. That's the Form I-485. And with that Form I-85, you're able to file for work and travel authorization as interim benefits during the time in which the adjustment remains pending. You're only able to do that if a visa is available based on your country of chargeability and the category that you're in. And since the enactment of the law in 2022, the rural, high unemployment area, and infrastructure reserve categories or set aside categories have been current, meaning people from anywhere in the world who are lawfully in the United States can file an adjustment at the same time that they file the EB-5 petition. Beforehand, EB-5 investors needed to wait for their I-526 to be approved in order to file the adjustment. So by able to file the adjustment at the same time, they are able to get these interim benefits and have a backup option in the event something were to happen with their non-immigrant visa status. Min, you mentioned all the people who are in the United States right now. Most of EB-5 investors since 2022 are located in the United States, not outside of the United States. They're here on short-term work visas or student visas. They don't see other options available for them, and they're turning to EB-5 because it's really one of the few options that are available to file the adjustment at this time. And we have a number of Indian and Chinese investors who are stuck in H1 or who are in H1B status, stuck in EB2, EB3 backlogs, or on F1, aren't able to find an H1B sponsor after OPT or something like that, and they are turning to EB-5. So there is a huge, huge benefit of doing the concurrent adjustment of status. And again, you can only do that if a visa is available. And based on what Suzanne was saying is that at some point, most likely in 2026, visas will not be available for most EB-5 applicants, particularly for the high unemployment areas and likely for the rural areas as well. And Suzanne's white paper that you guys all have downloaded is a really, really great resource. It explains it in plain English, all of the different options that different investors have to make sure that they can get the green card as fast as possible. And it's really important that you work with your immigration attorney and make sure that you are acting as quickly as possible to get your case filed and to make sure that everything goes as smoothly as you can. You don't want anything stopping USCIS from taking action on your case. If there are delays there, that means you're going to be further in the waiting for the backlog. One thing I say to all my EB-5 investors who are in the United States is a visa is available today that allows you to file your adjustment of status. But the visa bulletin must be current for your priority date at the time that the I-526E is approved in order for USCIS to adjudicate the adjustment. If there is a final action date that is before your priority date, then you are in that backlog. You're in the United States. You are in a period of authorized stay. You're not accruing unlawful presence. but you also don't have the conditional green card yet. We have to wait for the visa bulletin to advance for your priority date to become current, and then they can adjudicate your adjustment of status. So this concurrent option is a great short-term benefit. Ultimately, though, your green card and your family's green card is based on the visa queue that Suzanne mentioned, and there will be some wait time, particularly for Chinese and for Indian nationals. You know, one of the reasons why we are pushing so much information on this right now is because 10 years ago, this happened before, and not everybody understood it. And there were a number of Chinese investors in the unreserved category who made their $500,000 investment, who still haven't gotten their conditional green card because of the per country caps and the visa backlogs. So they invested 10 years ago. They still don't have their conditional green card. People are doing this EB-5 not for the investment, they're doing it for the green card. And so you need to understand why this timing matters. Your green card, I don't want to say is going to be delayed, but there is some time for it in order to get ripe. And in the meantime, you need to make sure that you are either maintaining your lawful status or making sure that you're kind of staying off the radar, because even though you're in a pending adjustment of status, that actually is not lawful immigration status. USCIS is very, very clear about this. You're not accruing unlawful presence, but you're not in lawful immigration status either. And so we advise our clients to maintain their non-immigrant visa status as long as possible. Easier said than done, in particular when there are extended visa backlogs. But that is the safest option. It gives you the most amount of protection, and it gives you the most amount of options for U.S. immigration moving forward. One thing that CanAm asked me to speak about was this 2026 grandfathering deadline. And I want to explain what that is because it's something that a lot of investors are asking about right now. So under the EB-5 Reform Act, an investor who files their I-526 by September 30th, 2026 is grandfathered. That means that even if the regional center program is not reauthorized after September of 2027, those filings still get adjudicated under the current law, and you're still able to get the immigration benefit from your investment. So that's very important, and why I think a lot of people in EB-5 are expecting to see a lot of activity in the next 12 months. And then come October of 2026, there will likely be a fall off. The question of how does this relate to the EB-5 backlog? They're next to each other. I don't know if they're really impacting each other. Grandfathering doesn't give you priority in the visa queue. You must still wait for visa availability, which depends on your priority date, your country of birth. And so there are visas that are still allocated to the EB-5 category because there still is the direct or standalone visas program. And so there are visas to pull from. And so eventually you will get that immigration benefit, even if Congress does not extend the program in 2027. My personal take is they will extend it, just like they have extended it, I don't know, dozens and dozens of times before, because it's a great economic tool for the United States. And, a lot of congressmen and senators have money that is brought into their districts through EB-5. And so they've seen the benefit for it, the jobs that are created in their jurisdiction. So I wanted just to touch on that 2026 grandfather deadline. I'll also say that, and I agree with Suzanne, that this is something that is constantly changing, which is why immigration attorneys are always looking at the visa bulletin every month it comes out. And we're always looking at it to see, has it moved forward? Has it retrogressed? Because it impacts a lot of our clients' lives. And so we do a monthly call on YouTube with the guy who used to write the visa bulletin. His name's Charlie Oppenheim. He's now works for WR Immigration, and he has got great insight. He understands this better than most. And so we invite you to take a look at our videos online about that as well. But really, the concurrent is huge because it allows you to remain in the United States while the time that your EB-5 case is pending and even throughout the backlog. And that's what's, I think, driving people towards EB-5 at this time.
I do wanted to build on this and just asking one more question on the latest visa bulletin that we've seen. I think the latest data has shown that as end of this month, there's still only a very small number of actual EB-5 visa been issued this year, despite the huge pending numbers of petitions that have been waiting to is already approved, that pending interview at the consular or waiting to be adjudicated on their 485. Does this mean that we probably are not going to see the actual retrogression on the visa bulletin later next year?
I think we will see it in 2026. As Suzanne mentioned, we need USCIS to adjudicate more I-526s, because only when those are approved will the Department of State see the demand for the visa numbers. And only when that demand exceeds the supply will they impose a final action date. So as USCIS adjudicates more, that demand goes up, and we will see a final action date in 2026, which is why I'm telling people that if you're looking to do EB-5, now is the time. Get your spot in line. You get your spot in line by filing the I-526. The other thing I want to say, because this gets asked me a lot, is you cannot port your prior EB-2, EB-3, you cannot, port those EB-2, EB-3 priority dates to EB-5. They're mutually exclusive. And so for people in the United States who are waiting in those backlogs, that does not benefit you for EB-5 purposes.
Thank you, Joey. That's very helpful.